close enough. And then yesterday during the hearing, Mr. Myers had said that he owns this. I looked up the Phoenix Times. There is a website called the Phoenix Times. It basically links to other news articles and posts press releases. I couldn't find any Joey Payne associated with that. And our public affairs representative indicated that the person here today is from RP Media, which is a different company. So I'm not at all certain who's actually making the request. And without that, I have time to stream this. So, Mr. Parvin, I'll start with your position on this.
Well, my position is, again, we've already ruled because there's no victims, or the court ruled no victims here. There are less concerns. There's objection to streaming. I mean, already prohibited Mr. Meyer from using his own personal device today, under the understanding that would be able to do it. That have as much interest, I guess, is the case. Mr. Myers was allowed to speak on his behalf, but not officially withdrawn yet. For the let Mr. Myers answer this question.
Mr. Myers, do you want to answer this
question?
Yes.
6 times is a DBA. Just it's a website name. You know what I mean? Do
Yeah, owned by. Hold on, it's owned by Newsmatics Inc. Is that in Washington D.C.?
I'm the host of the website.
Okay.
Host of the website.
Okay.
Do ads and stuff. So you have a website. Stuff like that.
Oh boy, guys.
Because it's not. They had a local guy. It's just an independent contractor.
Okay, but I don't really know who this is, and I evaluate
Today or
who. No, who the Phoenix Times? I don't. I have to evaluate. It's your media company.
Freedom LLC.
Okay.
Yeah.
All right. So this is your company basically.
It's a DBA. It's not an LLC.
Okay.
You don't have to have it registered to use it. It's so that we have,
but your company basically opened this website as Times.
my company Freedom,
Yeah.
which is multiple things under it. Started that way so people had a website to go do, and we could ads so that we could have Phoenix Times and all that in exchange. That company puts you out there, and then they run those ads on there, and they get ad.
Okay. All right. Let me.
We do the story, that kind of thing, but it's just like a hosting thing. You know what I'm trying to say? You pay to market you.
Let me hear from the state. Ms. Stiles, your position?
Who do we have here today?
Somebody who says they're from P Media, which my understanding, contractor that's been contacted by somebody to cover this. The Phoenix Times is an entity. My understanding is a website that the defendant opened.
Well, the rule's just very clear. It has to be that notice given court prior to. So if somebody else who's filming who didn't provide the notice to the court, they were entitled. We're still live streaming, so the recording's put out in the public. But if this isn't the who requested this company, the one that requested the permission, that under the rule they're automatically denied. That's my understanding of the rule.
I'm going to reverse my ruling. This is not what I thought of approving, and that's confusing.
Can I say
And-
one last?
Yeah.
Even though I'm not to overturn it, but just to clarify something.
Record.
Yeah.
Go ahead.
Is there a better way you want us to file that? Because it's ultimately free. It doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal. I just did not understand who was making the request, and it was confusing to me. And I'm concerned about the nature of the charges in a harassment case, about who's doing. So I'm not going to deny that for today's hearing.
Yes, Your Honor.
Yeah, hold on. I have on my list here before we.
I want to add to that could change and maybe the reason
Okay.
as well. Your Honor, we still believe that under the 1H, Mr. Munt should at least be able to use the personal audio recorder to record for his own purpose. I think that's the next. The reason he didn't object more at the last is because the court was going to allow a company to essentially film. We would have concentrated on that objection and filed more on why 122 allowed him to do audio recording. concern, because the only reason after the court's ruling without further argument, I would have filed more motions, was he understood the court was gonna allow some sort of video today. I don't know what's YouTube is showing, it's being live streamed, how people can access it. I'm familiar with it, but I think Mr. Myers at least would like his personal recorder of 122 he'd notice about it and be able to record.
I deny that. So let's want to quickly, so I don't forget. There's filed a motion to exceed the page limit, which I'm granting. That's for a slap motion. So
Thank you, sir.
I have an order, so I just wanted it on the record. Right. Next, before we the defendant's motion to himself, Mr. Parker wanted to say something.
Yes, come to my attention that rather than file all charges at where Mr. Myers would be available as a matter of right, this whole situation seems to be filing. Some police department officers in this room now, or if they're waiting outside to arrest Mr. Myers on new charges that consolidated with this court, which therefore deprived Mr. Myers opportunity to respond and represent him, say therefore forcing me to be on case against Mr. Myers to represent himself. That we be, if the state team is coming, that he, since this jurisdiction for these new charges, that we do initial appearance today, immediate that release conditions, so that Mr. Myers can continue to represent himself, because otherwise we're gonna have a real problem after grants this motion, because now attorney on the new initial appearance, and I'm this with the same kind of Feretta motion, doing this again. We got a real problem, Your Honor.
So we have a CRP now. Defendant's been held over, and I'm going to rule on that. I don't know what's going to happen if they're going to file an indictment, if there's an arrest before an amended indictment. That there's nothing pending that I could. I understand your issue, but there's nothing pending that arrests.
Well, I'm wondering if there's any information at all, because instead of arrested, he's going to get arrested on each. I just talked to the officers, so that's kind of it's going to put a problem here. How is Mr. Myers going to respond to motions pro se? At the same time, how am I going to be withdrawn? He needs patient, and then if there are new charges on new arraignment, the court's going to have to re me again and do this all over again. I'm the state information of all, because I mean these officers have information.
The styles.
Your Honor, I notified defense counsel yesterday that there were likely new charges. And so this defendant just happens to be in new offenses. And he faces, just like anybody else, ongoing activity would be facing new charges. That's the position he's in.
Wait,
So
let me ask this. If it occurs and it proceeds an indictment on new charges, that the CR or a new CR?
it would be a new,
Okay,
It's a
and that would be
separate-
assigned to me specifically. We assign all to the same Superior Court. So, but those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that?
There-
It's speculative.
there's nothing that he would have to go through the process, but there's nothing currently that would be in front of for the court to be able to do anything on.
The charges wouldn't affect these pending charges.
Correct.
We would, because it's going to affect potentially his eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr. Myers' slap motion. Now, I would have filed it slightly differently. Maybe I would have done a motion to dismiss under the or motion to remand once the grand jury comes in. There are things that I've done different, Mr. Myers, and I would have taken more time to do it. That's the reason I have to draw, so Mr. Myers can do everything that he wants, and he may or may not be, right or wrong, doing it different than me.
Right.
But that's a real problem, because if where the officers are, they work here now, get information, but if proceeding concludes, we go out and Mr. Myers gets arrested, custody, he needs a new initial appearance. I don't know when that's going to be. Obviously, of course, going to need back in on it. I'm going to have to appoint me again and then go through a new draw. And then I'm wondering, at this point, I'm trying to think for.
Well, we could do a couple things. We could put off if you'd like, to withdraw. I mean, that would be the.
His motion's filed.
Hold on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in the case or not. I have no information on. But if you consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's gonna happen as proceed crazy as this will be, proceed today with the motion to withdraw and Mr. request proceed pro se. My understanding is all motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed. And I'm guessing I will be notified new initial appearance. Now again, I have a calendar as well as my other OKs, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then on whatever new case is, we'll have to be right back here on the case and do this again. I guess it needs twice from what the court's understanding. But we'll do this today. We'll get through it, and Mr. Myers, we'll talk to the officer and find out what's going on before you are arrested.
Yeah. Again, we have to concern ourselves with what's currently pending, and I can't speculate as to different steps in the criminal process. And I don't get the case back until the defendant is held over if there's a new case. So, I think
This is just a very unusual case.
They did this on purpose.
I'm just explaining to the court why this. I understand what the court's saying. I just hope the court is how rare the situation is.
it's unusual, but people actually pick up new charges all the time. It's kind of a.
But I haven't done anything.
Yeah, I understand. I'm saying the usual person wants to represent themselves and
Right.
respond to motions, but normally it's just say the same attorney can help them all break up.
They're doing this so I can't type my computer. They just want me away from my computer.
Okay, all right. I'm not. That's not our today. Today our issue is represent yourself. So, and I know the last thing I wanted to mention is, Mr. Myers, I understand that when filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers, and we clicked on that, and there is only one filing system, and it is possible to mark action by the division.
I
So,
don't know where that is on there.
Mr.
I even clerk and went over it on the screen with her.
Mr. Garvin, have you tried to go over that with him? Just show him how.
The filing system, honestly, I've had issues there as well, where even if it goes to a pile, I find it much easier just to deliver directly to the clerk for the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online. But I believe, I understand if it doesn't get to them, there's a reason. I don't think the court's going to hold that against you, Mr.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There's a way to do it. It's just always more.
I don't know if it's because I'm pro se and they let me just send things directly.
Only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you, I wouldn't, if you have problems with the system, how do you do it?
Well, I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. Maybe it's just on someone's desk or doesn't get printed out, or it's in a list of documents. So I find it best, although as the attorney, it's easier for me to just follow up with, for example, the state or the chamber and say, did you get this? And to say, could you please email me a copy? And that way I have it. But I understand Mr. Myers' situation is a little different. I think it's best to use the system where it gets to your court at some point, and if it does not have it, I inform Mr. Myers it's still filed on time, and the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So I mean, it's important that we get copies. What I don't want is for Mr. Myers to email us all this stuff. That's not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running. We don't look at a case all the time.
Right.
We take action because something served on us.
And that is the problem I've run into before, when I thought I didn't follow up and I thought it was served on court and it wasn't. Again, it was easily fixable just because of what we just got an extension of time limits. But I understand Mr. Myers' concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's by email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay? All right.
I feel like this thing is,
Hold on.
I mean,
We're just talking about procedures.
But I know I'm gonna get arrested when I walk out and they're gonna try to hide me from my computer, so I can't even.
You're
so
gonna get a hearing on that.
How am I gonna be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction over that. We're talking about this case we're doing today. I don't,
You know what's going on. You saw the
No,
slap.
I-
It's gonna be a slap in the next one.
The court's not gonna read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can represent yourself.
But I'm
And
wondering-
hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly so that I get notice. But I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you can email the state's attorneys, Ms. Stiles, all right? So you should never email something to a judge without the opposing party knowing about it.
Talking about like when you add the names?
Yes.
CC, right? Okay.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you simply add the motion, you say, this is what the motion is in the body, that's it.
Right, then we'll make sure we have it, but I don't want, you've added a lot of stuff in the motions that,
Yeah, because this is all a BS case.
okay, but it's not proper. I can only consider what's filed in the court file.
I understand what you're saying, 100%.
All right, so, are we ready to proceed to, the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought in custody, you have nothing else to file at this point.
As to the motion to represent yourself.
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with you, that's what we're.
Okay, I'm saying even your slap motion's filed,
My
everything's
slap
filed.
motion's filed, but I had other stuff, that Rule 15 and all that, but they knew what they were doing, this is dirty
Okay,
tricks.
I think
Okay.
everything's filed, Your Honor, where we could proceed.
All right.
That way you're not harmed.
My thing is if you let,
I'm not smart for proceeding.
I don't know, you were saying that initially, a few minutes ago, that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the slap motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the slap, you know what I mean? But
Correct.
it's also knowing that you left the house today with your wife's car half fixed, and now I gotta go to jail, you know what I mean? And my wife can't get to work as an attorney in town because this is the level they want to take it to. I don't know, you know what I'm saying? What's gonna,
Okay.
I have a
now,
suggestion. Hold
now
on.
I have serious concerns about these people being
Hold
ethical.
on. Your Honor, I will accept the appointment on the new charges, considering the fact it'll be a separate case number that will address that. That way I'll be appointed on the new case to be brought in custody.
Will it be brought
and you can
in?
Still, eventually. And then we'll do this again on the second
So,
case.
yeah, there are no new charges pending.
Yes, there are. They're waiting in the
Hold
hallway.
on.
No.
You'll get a immediate court date on that.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill.
Well, how would
you'll be
I-
It's the
arraigned.
one where they got 10 days to get the grand jury. Okay.
So-
yeah.
So there's the new charges they're not before me.
They're gonna arrest me when I walk out.
It's not before me.
But then I'm gonna go to jail and I won't be able to talk to you.
Myers, I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you, about 10 days.
My car's sitting out there.
Okay, we're here on
Why can't you
waiver.
be respectful and professional?
I'm trying to be.
No, not me and you. These over.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm like, how am I gonna be able to respond? If you say, if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. But it won't work that way. I'm not gonna, no, it doesn't work that way. You're not gonna be prejudiced in this case because you've been arrested on new charges, okay?
Yeah, they're gonna say that I committed a felony while I'm felony for a bond
That's
for
different.
making a meme.
That's different. That's different than your slap motion. All right,
Well, I'm gonna put a new one on the next one.
okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
Well, I'm
really,
scared that if I give up my right now, I won't be able to have it in the next case.
Have you right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new.
so you get a new attorney in the new case, and then you can waive your right to that attorney,
Okay.
and you can file a slap motion in that
So there'll be
case.
CR over here, CR over here,
Correct.
judge whatever, judge, or you, maybe you.
Same
Okay,
judge.
so it'll be 14 over here, whatever the new over
Again,
here.
my understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently. And which means if I stay on this case, technically the
That's what
court
I'm
has
saying.
to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay, all right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, have a seat. Mr. Myers, I'm going to ask you a bunch of questions, okay? And it's just the rules I have to follow before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1, okay? So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12.
Graduate high school?
Well, I have a
GD?
no, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay. Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Have you ever been diagnosed with a serious mental illness?
No.
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct. If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I could go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a category 1 offender, which means you're not eligible for probation. So if you're convicted, prison only. Each one, the mitigated range is a quarter of a year, that's 3 months, and the aggravated range is, on count 1 is a quarter of a year to 2 years. That's a class 6, and then the others are all class 5s, counts 2 through 6, where the sentencing range is a half year to 2.5 years. And then counts 7 through 13 are class 1 misdemeanors, no prison available. There is probation available, or it could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count, count 14, the stalking is a class 3 felony. Again, if you're a category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of a long time in the Department of Corrections. Do you understand that?
Can I say something back?
I want to know if you understand that.
Yeah, that's what I wanted to clarify, something you said right at the beginning of that
Uh-huh.
little section.
Uh-huh.
About the felonies prior.
Okay, and you're under oath, and anything you say can be used
No, I
against
was
you.
wondering if you meant, do they have to be in Arizona?
No.
Okay. Yes, I have.
They have to be at a certain time period.
Yeah, they're
But-
26 years
Hold
old.
on, there is a way to strike it, but that's down the road.
Okay.
Okay,
So to answer the question corresponding to that little segment, yes, I understand.
okay. Now, if you do represent yourself, you'll be held to the same standard as lawyers. Do you understand that?
Yes, sir.
And you, I believe you have a paralegal degree, you said? But you understand that your lawyer, Mr. Parvin, has attended and graduated from law school and has practiced as a lawyer for a long period of time. You understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay, so what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time and has practiced for a long period of time in this area and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you that you're just simply not going to have by not being a lawyer. Do you understand that?
Yes, sir.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right. You have to make opening and closing statements. and you'll have to cross-examine the state's witnesses and examine your own witnesses. Do you understand that?
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
I do. You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to represent or prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses, review disclosure, and interview witnesses. Do you understand that? Although we will make provisions to try to make that as clear as possible. It is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about the difficulty. We're trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally, just being
You mean throughout the litigation?
yeah, just being a pro se person,
Yeah.
it may be harder for you to do it
Get
than,
them in and stuff, right?
all right. And then, when you represent yourself, you're gonna have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right, well, you think, I'm just telling you that's a possibility.
I
I'm not,
understand the optics. Yes,
all right,
that's what you mean, right? The optics of it.
yes, exactly. The service of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you is lawful, including the lawfulness of any search, seizure, or police questioning. If an act you may have committed actually amounts to the crime for which it's charged, or if you have another valid defense to the charges, or if you're found guilty, whether you should be placed on probation, required to pay a fine, or sentenced to a term of incarceration, and whether appellate review could be justified. Do you understand that? That service of attorney can be of great value in determining those matters?
I do, and if it gets past the slap motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do have face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Correct.
this CR matter,
Not whatever they're going to do out there.
correct, this case, this
Yes.
pending before us. And the answer is that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay,
I have one concern, Your Honor.
Sure.
is Slap motion at any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can get extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that slap motion. That's Mr. Myers' motion. That's why I need to be withdrawn. I don't know if there's a way to appoint me as advisor counsel and give me permission just for that one basis to look into the grand jury and file that one motion only.
well, if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisor, can I still file that motion?
Well, hold on, no, because then you're his lawyer. Hold on. What's the deadline for filing a motion for remand is based on what date?
So it's 45 days after they receive the certified transcript, so.
Okay. And you haven't received that yet?
I'm not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
concern with this.
I could extend that to 60 days. Ms. Alves, do you have any objection to that?
No, and like I said, I don't know when the transcript's gonna be ready, but they still.
Okay, all right,
We're not up against that timeline, so if they need more time even than that, we can always keep
yeah.
adjusting it.
So for today,
But can he file it or does
Not-
it have to
not-
be me?
It has to be
It
you,
has to be me.
but I will buy you time. I'm giving you time. Sorry.
yeah, okay. So what we're gonna do is today, I'm gonna enter an order, and I am ordering that the defendant has 60 days to file a motion to remand once the defendant received a certified copy of the transcript with the grand jury. So that's 60 days. If we're bumping up next to that, then Mr. Myers, you'll have to ask for additional time, okay? But
If I'm in jail and they mail it to my house, I mean, how would I even know I got it?
don't you,
So many copies, even though advisory.
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his.
yeah, if you're advisory counsel, I believe you continue to
If I
receive.
get notice of court dates, I don't know what the rules of disclosure are for that.
Okay,
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory counsel, so we make sure that we're still sending things through Mr. Parvin.
okay.
But that's not really representing myself.
Well, do you not want me?
Well, no, I'm
you have the
saying-
right. You could get me off. You want
I'm
me
just trying to make sure that like, if they're gonna send stuff to him, is it, well, then he gets it to me?
Yes.
So,
He's your advisory counsel. He'll still be able to communicate
but
with
I'll
you.
also get sent a copy, right?
You should, correct.
He's gonna send the both, is my understanding.
There may be, if, depending on his custody status, there may be different things with the media, but we work with that all the time with people who are in custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear that, right?
Yeah.
You heard what they said?
yes,
Yeah, they're dirty.
Mr. Myers, to waive your right to counsel under the rule, you also have to sign this notice of waiver. So Leah, can you hand that to him? And it's on page 2 that you sign it and I sign it as well, and then it gets filed with the clerk. All right, the defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. Today is the 20th. Court makes a finding that after discussing the matter with the defendant and have observed his demeanor, that he has knowingly, intelligently, and involuntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel. And then we will talk about the schedule here. So there's that gets filed in open court. And
I don't mean to interrupt. I just saw a text message. Someone mentioned they can't hear any audio on the broadcast. I was trying to make sure this whole thing was recorded with audio.
yeah, it says it's streaming active.
Okay, I'm not
So,
sure why I was sent that text message, but it's just what I was told.
okay.
Just can't hear any audio on the broadcast.
All right, let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand, so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? You just told them to disclose all this. We went out, they could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now now I'm just being I was just appointed and under the understanding that, after this hearing today, they would provide it to me and I would go home and start getting, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just gonna give you, it's like, I'm not even, the evidentiary hearing is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're gonna put me in jail and avoid me. That was the whole point. I wanted you to order them to disclose it to me, and you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're gonna be showing me this, that, or whatever, could you send it to me, right? So that implies to the court right now that they knew as of right now what they're gonna send, or yesterday, or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're gonna show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit, and then they'll be like, oh yeah. And I had no time to prepare, no time to argue, and my lawyer can't prepare because I just took him off the case. This was all a setup. They could have.
Okay, so Mr. Myers, a couple things. First of all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off, or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you, so you've actually seen the video.
But it isn't, sir, that's not so I'm supposed to assume which ones they're going to use? I don't know I make hundreds of videos. So that's like saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing, and they're going to bring up videos there, they need to tell me, because those are different. Because remember now, this is a hearing for the conditions of release, which means things that happened after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been, you get what I'm saying, given disclosure specific to, because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so, and it was not even him, it was somebody else. And so what I'm saying is that how do I, not for the indictment, which is, like you said, you got time for that. Specific to this hearing, now they're going to put me in jail. And they could have, it seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying, it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No, videos. I got 586 videos.
Okay.
Which one?
So Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So you
Your Honor,
understand?
may I respond?
Sure.
Your Honor, so we've already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out now. Mr. Myers will make sure he has access of all the videos that we're referencing. I'm also happy to provide a list that I can send to Mr. Myers that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is required that we disclose those to him, and we're absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So Mr. Myers, when we come back next Tuesday,
Suppose the court has Friday available, so I can come too. I'm just trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input, and Mr. Parvin was here. I don't understand what happened to the
Weddings
dates
have come
yesterday.
up, and as we draw this, if Mr. Myers needs me, I think his question is.
Advisory council, right?
Except advisory council, he should have been preparing to be there because advisory council should be at all the hearings.
We were, but we didn't know that. Now I'm going to go to jail today.
okay, hold on. So you'd rather do the 28th than the 27th?
That way I don't know how long, it sounds like it's gonna go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims.
I can. Okay.
Is she gonna contact the victims right now?
Yeah,
Okay.
she's gonna reach out.
All right, let's wait for just a second on
I'd
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
That'd
Okay.
be only a quick half an hour here.
Sounds like they'll make it work.
Okay, so we're gonna change the hearing on the state's motion to modify conditions of release from the 27th to the 28th. And that will be from 2 to 4:30 I'll have set aside for that, okay? So, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll address that. And obviously, Ms. Stiles can respond to that as well. And your slap motion is pending before me right now.
So me getting arrested or anything won't, this case can work independently from them arresting me when I walk out?
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
You know, the slap motion isn't really something that's, the criminal side of it isn't something that's really well defined yet. So like, it's not really even in the rules of procedure. So I don't even know, is it gonna be a standard 10 date? Because it's not even something they're required to respond to unless you order them.
Correct.
So I don't know, is there a set period that you have to make your ruling
60 days.
before you order them whether to respond or not?
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So,
And also, my understanding is you can rule on it without an evidentiary hearing, or you can, if you.
correct, I could rule on
I
it.
would prefer to have one if, you know what I mean?
All right.
Unless you
So-
feel, you know what I mean?
Well, I have to make that decision. I've started to look through it. It's pretty long, like what, 25 pages or something. So I haven't read the whole thing yet.
I know.
Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count.
I mean, that's the only way I could do it. That's why I had to exceed, because
I'm-
it's like
yeah.
15 pages for each count.
I'm
but I
not
couldn't make a
criticizing you.
79, 80 page motion.
I'm not criticizing you. I'm just saying that it's gonna take me a while to read it all. I have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions in this anti-SLAPP. But it's there and we'll address it, okay? And that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. There's 500 videos of this same person that nobody else is being charged with except me. There's video. So what I'm gonna go here, I want you to hear this right on the record. I'm gonna go to jail right now, and there's gonna be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. She's gonna get 500 new emails,
Mr. Myers,
500 new memes made about her. How does that protect the victim? It doesn't. This is a charade.
Well, it may be. I
You
don't know
better
if
charge every single person, and I want you to address this on the record, because you said this yesterday, and we kind of talked about it for a second.
Slow down.
Slow down. I thought you said sit down. I apologize. Slow down. All right, so I would like to address this, something you said yesterday, because it's very pertinent as a matter, you're the trial judge, right? And so, you know, I don't know when I'll get back to my computer to notice adjudicated fact, but you ordered me, not asked me, you ordered me yesterday to remove your email from public posting, right? Because Gina's email is not, you know what I mean? And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, you know, and I mean, are those people gonna be charged with crimes? You know what I'm saying? And so this is pertinent, and I want this on the record, because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's gonna be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other people did. So in that case, when we come back on Friday, you should have there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay. And do you understand who makes prosecutorial decisions? You understand that? Who makes prosecutorial decisions?
We're
Not
good.
me.
I know. But I'm saying, so I should expect to walk out there and get charged for all those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
Who? You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not an
saying.
executive.
You're not,
branch.
what I mean is over at like Justice Court, they get elected through votes.
Hold on. You have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people could make a video about you on there and say, oh, I don't think he wears nice shirts, or I don't like the ruling he made in that case, right? They're not gonna get charged with the felony,
Okay.
but I am.
Right. Again, we're pending, we're addressing the charges pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but we're just trying.
Yeah, we're not
I just
there
want to
yet.
make sure because I want.
We're just trying.
Yeah, we're not
I just
there
want to
yet.
make sure because I want to tell my friends to get.
The schedule, and I'll just affirm the case management conference of April 15th and the pretrial conference of May 16th, both at 9 a.m. You are ordered to be present at those hearings. If you're not present, then the court can issue a bench warrant for your arrest. Do you understand that, Mr. Myers?
You, sir.
All right. Anything else we need to address today?
No, Your Honor.
Just that the court already said that in the event that jury trial does go, I don't think it will, that we would waive my presence that on April 15th.
Oh, you mean the pretrial,
Not the
case management conference?
Right.
And if they need to reset the hearing, we'll be fine with that. We can always work with the dates as we get closer.
Okay,
I don't
yeah,
want to reset it now because I don't think that trial's gonna go.
okay, yeah.
Why did you say that though?
What?
Why do you say it won't go?
Because things always, a lot of times you get notification, may either get continued or settled before the actual jury trial date.
Yeah,
That's
well,
just-
I'm not giving up my.
I'm not talking about you.
Different case. He's got a different case. Maybe he's got a conflict on that date, but he's saying that.
Talking about in this case, the trial
No,
might not go.
no. I was talking about a reason why it could probably still be available on the 15th. I'm not gonna make continuance unless I know for sure.
In your case.
Right.
Okay, I thought you meant in this case.
All
'Cause
right.
I don't want to continue anything.
I know you don't. That's why.
This shit should have never happened.
With that, we're adjourned and you're excused.
All righty, guys, you still there? So, did everybody hear me? Put a 1, yes. All right, so anyway, just to let everybody knows what happened, I put in a request to notify them of 122H that I was going to be there, and to request to audio and video. So as soon as I did that, a couple days ago, they sent me a thing today saying that they was going to do a live stream, so I wouldn't have to come in. They was going to do a live stream, so I didn't go down there. And then, they said they was going to put the audio and video on the live stream, but the judge, I guess right at the last minute, decided not to, after they already, told me I didn't have to come down there to do it. So now they're going to arrest him. I take it they're doing that. I don't know if it was just the judge deceiving us or if it was Dick Tracy and Mrs. Meadows, the one that's in control of the community relations. But they did us dirty because I would have been there if I would have known they was going to do this, because they said they was going to put an audio and video up. They was going to put it on their own live stream to everybody. And then they sent me a link to it. And that's the link that you just watched. But as you know, they did it pretty dirty. So I'm going to put in another request for his next hearing. And I ain't going to let them do that again. I'm going to be going down there because these guys are scum. The judge, as much as the Dick Tracy, and the guys that run the security there, they didn't want nobody there because they was going to arrest him afterwards, and they knew all this. So that's what I'm gathering. Oh wow, RP at video, no audio. Yep, they're doing some dirty things. I'm telling you that. So yeah, they're doing some dirty things. But anyway, that's the way they do it. So anyway, I'm going to get off of here. Anybody have any, I called the setup on his ass in the last RV. All right. You need your wrench, Aaron Queen? Yeah. I give people a wrench so people don't time them out. But you time everybody else out. That's my only rule, is let people have their freedom of speech. People with a wrench that time other people out, I do take the wrench away. Hey, so get outside. It's a nice day out here in Arizona. I think it's close to 80, maybe a little bit more. All right, so thumbs up, Tuck, thanks. But I don't know if they are going to arrest him. Okay, you want me to show you the pineapple? Well, actually, I got pineapple plants, but no pineapples yet. Once you take a pineapple, the mother plant I still have, once it makes one pineapple, it doesn't make any more. Now, it'll be a mother plant for other ones, and I took a few of them off that same mother plant. But I will show you the mother plant of the pineapple, Aaron Queen, so you can call it fake. There it is. There's the same mother plant that had the other pineapple. This is one of the babies from it. This is one of the babies from it. Hidden under here. Let me get that out of there. There's another one of the babies of it. And there. And I think these are all bananas, which Aaron Queen are fake. Looks like it stinks in there. Yeah, the whole purpose of this room is not pineapple and bananas. Of course, you guys know the purpose of this room is what you're looking at right now. My grow room. Pineapple Express. Are you calling that fake, Aaron Queen? Someone call the ATF? Yeah, ATF don't do this. All right. So anyway, yeah, I was supposed to be there until they sent me that. So Dick Tracy, Judge Metcalf, and or Mrs. Meadows all are part of this conspiracy. I understand why they don't want people there, and they did that little trick. So I was able to get the audio, but nothing else. So, any other questions? Sweet Narama, thanks for showing us. Nice setup. Yeah, I'm one of the few people that does hybrid. See, I use the sun, and then when the sun goes down, then I can turn on the lights to get me through and keep me in veg state. Because you need 18 hours of light in veg state. So I can use the sun all day instead of an indoor grow that has to use 18 hours of light, artificial light, which is expensive. So that's why. What strain is that? Oh, I say with this one here, there's two different strains. One's 100% huckleberry. One's 100% indica. And I can't really say it very good, but right there, 100% indica, and there's the brand. TASH. What? QR. That one I can't see very good. It's already wore off. Let me get another one. But I wrote it down right from the. There we go. That's the name of it. And then a couple of these are huckleberry. Huckleberry GMO 6040. Let me put my, oops. So anyway, how I water these, this right here holds my mix. It comes from my swamp cooler on the other side of here. It goes through all the pineapple. All the pineapple are hydroponic. It goes through here. It drops into there. I have a clean machine that every 8 hours it drops it into there. Then it goes through there. And then out to there. Then I got a switch right here that I can turn on and water all my, the other ones are hydroponic, but these are all dirt. I have to water. So, as you see, it's a pump and just pumps it out there. So I can water all my plants, which I'm doing right now. So, and then I mix, like I said, I mix all my chemicals down there. So, that's all it takes for me to water them. That's about it, guys. No, drink from the hose. Nope, that's chemicals. You see them chemicals there? And I'm getting ready, the budding chemicals are right here. That's the full, they ain't even started on that yet. Because I'm still in veg state. And I'm getting ready to switch over right now because I can't go much higher than this because then it goes all the way up into the sun. And that's about the highest I can go is about a little over 8 feet. I try to keep them around 7 feet when I start. So that's that. And I grow cactus. As you see. All right, guys. All right. Any other questions? cacti. Yep. Yeah, I got some, I got all different types of cactus. As you probably know, I think you've seen past live streams. I got up to 20-foot cactus all the way around my whole property. And I got quite a few. Saguaros. As you can see. And of course, that cacti. All right. Anyway, guys, I'm going to get out of here. Yeah, this biggest one right here was in a pot. It was about 6 inches tall when I moved in here. I planted it after about probably a year. I planted it right there. And now, as you can see, it is taller than me. Say it's probably 8 foot. So, all right, guys, I'm going to get out of here. So, all right, talk to you later, guys.